Good morning. Welcome to Member Focus Monday. I'm Christina Schaefer, Social Media Manager for HAR. I'm joined this morning by Grant Harple. Grant, welcome.
Morning.
How are you doing this morning?
How are you?
I'm very good.
Good.
So if we could just start out, Grant, I know you've been on this program before, but for people who haven't heard from you before, if you'll just introduce yourself.
Yeah, I'm Grant Harpold, legal counsel for HAR.
All right. How long have you been legal counsel for HAR?
Probably 6 years.
6 years?
Yeah, going on 6 years.
and a series regular here. This is, I believe, your third appearance?
At least.
Yeah, at least. Okay. All right. So Grant is joining us this morning to talk about a few things. Avoiding risk, right? Keeping it legal. So that's what we're talking about today. And we're just going to get right into it. So this is a question that we get a lot. I know myself, I get this question a lot from our members. And it's, pardon me, something that we've had clarification on in the past, but it continues to be confusing to our members. And that is just, what are TREC's requirements on the IABS and the Consumer Protection Notice?
Well, first and foremost, if you have let's just start with websites. And if you have a business website, they call it business website, but any sort of website that where you're promoting yourself or your business or anything related to your work as a realtor, that's going to be considered a business website. And so that's going to be sort of a source of the consumer seeing you or getting to come in touch with you for the first time. So that activates the IABS form and the consumer notice form. And so a link to both of those forms need to be on your business website.
Okay.
And then so that also applies to a social media website like Facebook or so forth. And so on Facebook, you can have it at your account profile where you would have the link. You can have the actual links there, the consumer notice and the IABS link, or you can have a link from your account profile back to your business website or some other link that will have the consumer notice and the IABS form. So for instance, if you don't have those links with those notices on the account profile, you need to have a link, let's say, back to your homepage of your business website where those links will be located. That is the links IABS and consumer notice links. So, with it, just think in theory, is it as if you're meeting this person for the first time, you would physically give them the IABS form. And so that also applies to website, to your email, where you need to have the link above your header in the body of your email, not below your signature line. And so it's just, once again, the effort by TREC to get this information from the very beginning to the consumer.
So as far as other social media platforms, you mentioned your Facebook business page. Is it required on other social media platforms?
Yes.
It is?
Yes. Any space where you come in contact with the consumer.
Okay.
So I don't think there's really any way to get around there. And I haven't seen TREC carve an exception. So somewhere in your account profile or in your About Me or whatever it is page that allows somebody to dig deeper to who you are, that's where it needs to be at the minimum.
Okay. So although TREC only specifically names Facebook,
right,
we should still have it on every platform.
Yes.
Okay. Now, what would be your recommendation if there's a platform where that's not really an option? Like, for example, Snapchat.
Well, I still think, and you help me on this.
Okay.
There is sort of isn't there sort of a setup page or an about page or something?
Not really on Snapchat.
Not on Snapchat. Okay. All right. Well.
So would your recommendation be to just not use it?
Well, I wouldn't use it for a way to advertise or to promote yourself to the public.
Yeah.
So if there's not a way, you made it real simple. Thank you. If there's not a way for you to provide that consumer notice and that IABS form, and you're on a platform that's promoting your services or you as a realtor, then those need to go together.
Yeah.
So if you're promoting yourself somewhere in a social media platform, then you need to find a way that provides those links to the consumer.
Okay.
If on that platform, Snapchat or whatever, you can't provide that link, but you're promoting yourself and your business and who you are in the industry, then you should not be doing that unless you have that ability to provide that link.
So you're taking a risk if you are.
Yes. I mean, just because Trek hasn't promulgated anything doesn't mean that you can still get away with it. I mean, so, and I've yet to see or hear of a Trek enforcement on any of this. So there's not really an example, let's say, to look at and say where they, whether you read about in the Realtor magazine or whatever. I have yet to see or had an experience with Trek investigating or coming down on anybody on this particular issue. So it's sort of unknown in a sense, and so just apply practical common sense in that if you're reaching out to people, like I said, whether physically or social media, it's the same concept. That information has to be provided to them in some manner.
So these rule changes, these are pretty recent, correct?
Yeah, they were. What were they? 2000, about a year ago. I think they did them in 2017, but they became effective in 2000. I think in May of 2018.
I'm kind of asking you to speculate here, but do you think that we'll see changes to these in the future?
I think as Trek gets a better handling of what they're doing and maybe has an experience on enforcing one of these, yes, we could probably see a more explanation. I think Trek right now is just focusing on answering telephones when people have questions. So.
Lainey, just to throw this in there, Lainey Brown said Trek has enforced it. So maybe she knows of an example where it has been enforced.
Well, good. Yeah. So, I mean, right. So certainly possible. I just haven't had that experience or had anybody discuss it with me.
So moving to a little bit different topic here. As far as we're coming up on hurricane season again, people start talking about flooding and things like that. What is the agent's responsibility on ensuring that seller's disclosure information is correct in regards to flooding specifically?
Well, I think first and foremost, making sure the seller, your client, understands the importance of getting that information right on the seller disclosure, getting all the information right, but certainly that one. And if you look at the question at the beginning of that section, which I think I have somewhere, it uses the word aware. So it doesn't say, it's not asking the seller about personal knowledge, which personal knowledge would mean I'd have to have seen it or known about it myself personally.
Sure.
Asking the question whether you're aware, I think, is a much broader sweep. I mean, you could be aware because your neighbor told you something, or you could be aware because the previous seller disclosure told you something, or you could be aware. So it's a very broad definition. And so when asked aware, if the client, your seller, is aware but doesn't have personal knowledge, and that needs to be disclosed. And so I think that's the importance. And I think specifically on flooding, it's two questions. It's into the structure and onto the property. And I think onto the property is probably one that doesn't get as much attention, because onto the property means into the yard, let's say, and so that's still important. If it comes out of the street and into the yard, that's onto the property, your property. Just imagine what the survey would look like if water came into where the borders of the survey, then that's onto the property. And so, it's funny, I think there's two bills, Senate Bill 1220 and Senate Bill 339, that have been filed in the legislature right now in Austin. They haven't come to hearing yet, but they have been filed in both bills. I think one was filed by Betancourt and the other one by Joan Huffman, seeking to update, if you will, the seller disclosure and making the flood disclosures a broader, almost a half a page process. Right now it's 2 boxes, 2 questions, 2 line item questions. What I've seen is being proposed is that it would be a lot more definitions and a lot more questions and more information. So instead of right now you have like that, and now it would probably become this.
Yeah.
And so I just signed up this weekend to get alerts as those bills go through the legislative process. So hopefully I'll get alert when there's a hearing or there's been a change to it or something going on, because I think it's important, not just for me, but for all of us to provide input, especially people who are in the business, to provide input on how that wording ultimately, or how voluminous that information should be inside the seller disclosure notice.
Yeah, and I'm sure we'll be paying really close attention to that as we approach Realtor Day at the Capitol.
Yeah, so
later this month.
Yeah, so it's SB 339 and SB 1220.
Okay. So in regards to flood, the city of Houston just a few months ago released a floodplain ordinance,
right,
with some changes. So can you explain the new city regulation, and then also how can agents protect themselves when they're representing buyers in those areas?
So this came about and became effective. It was passed last spring, about a year ago, and then it became effective in September of 2018. And so what it redefined building in the floodplain. It used to be that essentially new construction in the floodplain the finished floor had to be a foot above the 100-year floodplain level. Mm-hmm. Now, new construction in a floodplain has to be 2 feet above the 500-year floodplain. So, generally speaking, if you're building new construction or you're doing a substantial remodel of a property that's in the floodplain, whether it's 100-year or 500-year, the finished floor on a new construction has to be 2 feet above the 500-year. And then on a remodel, it's just, to some degree, they may not permit it if there's too much of a remodel to the property within that floodplain. They may or may not. It's that, and it's somewhat tricky. They may or may not approve the substantial remodel of a house in the floodplain. Meaning, I think the theory being that if you're going to make all that substantial improvement, just go ahead and tear the thing down and start over and build it up. I think is what they're trying to. If it's not a substantial remodel, then okay, there's not a lot of capital being spent or being put at risk. And so I think so that's kind of in general, that applies to the city of Houston and Harris County. Mm-hmm. It may not apply to Bel Air or Westview or some of the villages. So that's just city of Houston and Harris County.
Okay.
So HAR came out with a form, and we hopefully will be rolling it out this month. That if you're representing a buyer, because I think it's important to a buyer to know that if they buy a property that is maybe an old ranch house or something that might need some major remodeling or even tearing down in the future, and they're just maybe the people buying it are just planning on living there for a while and maybe doing something substantial later, they should be aware going in of what they will have to, and generally what they will have to be doing in the future. And so we came up with a form to alert for the buyer's agent, because this is most likely where it would come up, mm-hmm. to have the buyer sign off on a disclosure telling them in general about what the city has done, what the county has done, and that they should, if that sort of plan is in their mind, they need to go check with the city ordinance or the Harris County ordinance more specifically to see how it might apply to their specific property. And I think probably the most important thing in all of this is knowing if the property's in the floodplain, and B, where in the floodplain. Mm-hmm. You know, is it you need to know where the 500-year floodplain level is the important factor, not so much the 100-year floodplain level.
Okay. So Gary was asking, how accountable will sellers be for environmental living conditions due to mold issues after sale?
Well, there's, that's always a risk, but I guess it depends on what the seller knows. I mean, we start with that basic premise, what the seller knew or did not know relative to the condition of their house and relative to the environmental condition, and more specifically relative to the mold. That some of that may be discovered during the inspection process. And so then that risk perhaps comes onto the buyer. And so it really, just like a flooding situation or any other potential defect or issue with the property, it depends on what the seller knew or didn't know. If the seller knew about it and didn't disclose it, then, that's a problem. But the seller did not know about it and it comes up during the inspection, then maybe, and the buyer still moves forward, maybe it's a buyer issue that they, took on that risk.
Yeah. Donna actually asked, back to the Senate bill alerts that you mentioned you signed up for.
Yes.
How do you sign up for those alerts?
So Google Texas Senate, and you should be able to get to the Senate homepage, or you can just Google SB 339 or SB 1220, and they'll take you there. And then on that page, you'll see a menu of items, one of which is alert on bills or follow a bill or some sort of language that kind of tells you that possibility can happen. And then you just set up an account, you get a password, you kind of log in, you identify which bills you want to follow, then those should go into the system and should start getting alerts. So like I said, I just did it Saturday. So we'll see how it works. I mean, I put down those two bills, and I felt like I got them into the system, and I did get a confirmation of my being in the system. So it's just getting to the Senate homepage or the legislature homepage where you can look at all sorts of things, including that, and just following. It's pretty easy. So just go to Google.
Go to Google. Marco was just following up on Gary's question about mold. He just asked, would environmental assessment addendum cover this?
It could, yes. I mean, I still think at the end of the day, if we're talking about the seller's responsibility, we're still talking about seller's responsibility. And so ultimately, any of this, an environmental issue or any issue, is still, if the seller was not forthright about it, then that's a problem. Or even if the listing agent knew something about it, that's a problem. And that goes beyond seller disclosure. I mean, I think, these types of issues that would be weighing on somebody's mind, and you would expect would be weighing on a buyer's mind, should be upfront. I mean, whether or not the disclosure covers it specifically or not. And that would be one of them, covered by the disclosure or not covered. If there's an issue with the property that could affect its habitability, then that needs to be disclosed, whether the seller knows it and or the listing agent knows it.
Okay. One more thing in relation to that I see right now. And again, if you have questions for Grant, type them in and we will get to those questions. We have a few questions popping up right now. FEMA has not updated maps in Montgomery County. How do we ensure that we have accurate information for our buyers?
Well, and don't feel left alone. Harris County hasn't been updated either. And so, and that's kind of my understanding, that's some years away. So I think it's still ultimately dependent on the survey and the elevation certificate. So when you go to buy a house, or if you're even thinking of buying, you don't have to do it even in the buying process. You can do it in the option period, perhaps, or whatever it takes, I guess is what I'm saying, depending on how big an issue it is to you. The survey is key, and getting the survey to do an elevation certificate, and then that will tell you where you are specifically relative to the 500-year or the 100-year or the floodplain in general. And so you can go on the FEMA map, and the FEMA map is pretty good, where you can kind of dial into literally to your address, and you can pretty well get a good understanding that way, especially if you're just canvassing the neighborhood or a particular piece of property. ultimately, the specific detail of that floodplain level relative to your property will be the elevation certificate, which will come via your surveyor.
Okay. Several people are asking about your thoughts or comments on the class action lawsuit that's been filed against NAR.
I'm just like everybody else, just curious to see how it plays out. And since NAR is the named party to the lawsuit, I'm just deferring to what they have to say or how they respond to it at this point.
Okay. So getting back to Trek, we were talking about Trek a little bit earlier, but getting back to Trek, what are the Trek rules on advertising?
Well, I mean, I think the biggest thing that we being HAR, were very instrumental in making it fair and reasonable for not just the consumer, but also to the broker and to the licensee, is that whatever ads you have, you as a licensee or as an agent promoting a property and your contact information, all that sort of stuff,
Mm-hmm.
you need to have your broker's name on there too. And so the broker, wherever you're promoting a property and you have your information, your broker's information needs to be on that ad too. And half the size, something noticeable, but they do, Trek says basically half the size of the size of the language that your contact information is in. And so
Okay.
when I say broker information, I'm just saying literally the broker's name.
Mm-hmm.
And it needs to be the correct broker's name. And so, hopefully that's an easy issue to nail down, how your broker presents itself to the public. And the most specific way to know that is to however the broker's name is listed in the Trek website. Or if you look up a broker under Trek, you will see their name, and that's how it should be in the advertisement. And so that's the point, is that the consumer, if they see the broker's name on your ad, they can be assured that if they Google it or if they go to the Trek website, they can match up that broker's name to what's on your advertisement, and they can see the broker contact information if they need to contact your broker for whatever reason, good or bad.
Is that any different for teams?
Well, in the sense that no, the broker's name is still needs to be part of that. And so the team name is going to be still a registered name also.
Mm-hmm.
And so that's something, and Trek has promulgated rules on that too, on what a team name can have in it. But the team name is going to be registered also, and so that needs to be accurate. But also the broker's name still needs to be on there, no matter who the advertiser is, whether it's the individual licensee or team name. And so once again, the point is to have the consumer informed as to who the broker is, because ultimately the broker is the one responsible. And so that
Right.
if the consumer, like I said, has a good issue or a bad issue, they have a readable name that they could see and follow up and make contact with, which is similar to why that information is in the IABS form. So it actually starts there, and that was part of our argument all along, is that the IABS is really more of the drill down to broker information. Mm-hmm. Yes, let's have broker names on advertising, but let's not, have too much information where the advertisement doesn't look well.
Okay. Following up on that, Kelly said, major franchises don't do the broker name, but they're registered with Trek. Can my company name suffice if I have a DBA filed?
Well, if the DBA is your name that is filed with Trek, and that's the name and I'm not sure if you're talking about the broker or the agent, but let's talk about the broker. If it's Grant Harpold is the Grant Harpold Inc. is the company, mm-hmm. but my DBA is Harpold Properties. So, and Harpold Properties is registered as my DBA with Trek, and I'm the broker. Then on the advertisement, Harpold Properties is what should be there, because that's how I'm presenting me as a broker to the public.
Okay. So Marco, again, just to clarify, said, when you say broker's name, does that mean the broker of record or LLC brokerage?
Well, it's the broker of record. So if it's an individual that's the broker of record, then that's who it is. If it's a company or corporate broker name, then that's who it should also. So I mean, yes, some people have the corporate name or corporate broker, and so that's fine. That's the name that should be used. And others who don't do it that way, but you're sponsored by an individual broker, then that's the name you should use. So it's whoever your responsible broker is, which can be corporate or which can be individual.
Okay. So there was a question. Rashmi is asking, if a house was flooded and is listed now, what are the relevant documents that a buyer's agent should obtain to safeguard the quality of repairs and other issues?
Well, I think you're kind of still back to the situation of depending first on what the seller provides you, and then taking that information and maybe using it to perform further investigation if it's important, or if there's something that's not quite clear in what information you're getting. So, I mean, the seller probably can only explain so much about repairs and remodeling and all that stuff in a seller disclosure notice. I think the point of the seller disclosure is to alert you so that then you then go get more information. And so presumably you'll be alerted about flooding, or presumably you'll be alerted about remediation or remodeling work that was done. Then you can ask as a buyer's agent, and you should ask the listing agent for perhaps the backup work, the contract that was done, work done by the contractor, who the contractor was, and maybe a line item of what was done. Presumably the seller, when it did a remodel, had a contract with a contractor and this work was done, and they can hand you the box of information literally. And that may not be the case in every situation, but that's, at least you should be asking for that, and in some situations, maybe the seller kind of did it on a handshake and all that documentation doesn't work. And so, that's you as the buyer or the buyer's agent, something to consider on the quality of information you're getting once you're alerted to the fact that these issues exist. Mm-hmm. So it's your burden, I think, as the buyer's agent to help your buyer obtain more information if it's important, of the issues that you've been alerted to in the seller disclosure.
Okay, very good. So that actually looks like all the questions from our members. Do you have anything else that you wanted to share with us? Any updates or anything we should know?
No, I think we actually covered a lot.
We did cover a lot.
So I think this, and I want to say this popped up somewhere recently, back to this issue on the building in the floodplain. I think that's sort of especially from a buyer's agent standpoint, I think that's an important issue for anybody buying a somewhat aged house, or a house that might need a major overhaul, is that they know going in that there's new rules that apply, and to what you might be able to use that property for in the future. I mean, so back to 2 feet above 500 year floodplain level might be pretty tall. And so here's your buyer looking at this ranch house that they bought, and it's a nice lot. And yes, they were thinking they may have to raise it a little bit if they ever tear it down, but they may have to end up raising it 6, 7, 8, 9 feet, depending on where they are, which perhaps may be overkill. And that was some of the arguments against that ordinance when it was passed. It was passed by one vote, by the way. And so height of your future house could be an issue. And so I think that a buyer who is thinking that relative to a piece of property they're buying should be made aware of those issues of building in the future, and should investigate that. I mean, at least somebody should investigate it. Presumably the buyer will, once they're alerted to that issue.
Okay. A few more questions rolling in here. Jeff asked, when has or will the inactive MLS approval be required?
I don't know. I'm
Uh,
not sure what that is.
I'm not sure either. If you want to clarify that, Jeff.
Sorry,
we can,
Jeff.
Yeah. Rashmi said, any certification or inspection report was required after the repairs of a flooded house? Or so are there any, is I think what she's asking.
It's not a requirement, but it's certainly an advice and a good thing to do, that if, you know, that you would want an inspector to review what was done. And back to what I was saying earlier, if you can get information from the seller or the listing agent relative to what was actually done by the contractor, so not only can the buyer review that, but also you can hand that off to your inspector. And so when the inspector goes to the property to do the inspection, he or she now has this more information that he can kind of zero in on and look at specifically and doing his inspection. I mean, the inspector still has his routine and his form stuff that he goes over or she goes over. Mm-hmm. But if whether giving actual written documentation or even verbal information about here's what was done to the house, can you really focus in on that, Mr. Inspector or Miss Inspector, when you go to the property? That would really be helpful to us. So I think that's where it's important. And it's not so much a requirement, it's just good business.
Gary's asking what your opinion is on using free attorney advice from the TAR attorneys.
I think yes. Make that call. And I know most of the lawyers there, and I think they're pretty good on what they're doing, and they try to do their best, and they may not have the answer right then handy, but they may come up with it later, or you can follow up with them. So I would absolutely use that asset.
Mm-hmm. Jeff clarified, he said it's coming up in back agent, inactive MLS approval by seller. I don't think we.
I'm sorry, Jeff. I'm just not plugged into that issue just yet.
So Rabina said, how can we be sure an agent has actually presented our offer? I know there's the form, but I'm sure a contract this weekend has not been presented, as it is strong, and I cannot get the agent to return a call.
Well, that's a good question. I mean, I'm sure that pops up in your head or other people's head a lot, and I think it's just back to ethically that responsibility exists. And then as a matter of law, just in a fiduciary relationship, that responsibility exists. And what I'm saying is there's just somewhat of a trust factor here that the listing agent ethically and as a fiduciary to the seller is presenting all offers. And if they're not, then that's the risk that I guess that's a decision they've decided to take and take on that risk, if you will, and there's not really much you can do about it unless, it becomes so flagrant or so obvious that, it becomes an ethics issue that you can report to TREC or to TAR.
Yeah. This is my question, not theirs, but the city, the city ordinance that we talked about earlier, you said it was just in relation to Harris County and the city of Houston.
Yes.
Do you see other counties and cities locally maybe trying to do something similar?
I thought so, but I'm not aware of I'm not aware that Bel Air or Westview have gone to that extreme, and I'm not aware of Montgomery County or Fort Bend County. Mm-hmm. And to be honest, I haven't done any research, but just in keeping up with the news and just community talk, I haven't heard anything more than what City of Houston and Harris County have done, which it was sort of on the extreme side and mm-hmm. barely passed. So we'll see how that works out.
Okay. Well, that looks like all the questions again. So thank you so much, Grant. This was really helpful.
I hope so.
Absolutely. Is there anything else you want to throw in there?
I mean, I could keep talking, but I don't. I guess I'll stop.
Okay. We of course will have you back.
I guess my last thing is that the seller disclosure. We all need to keep up with that. That's an important document. We want it to be a good document. I don't know what the legislature may do to it, but it's something we need to keep tabs on, and
Yeah.
and
Sign up for those alerts.
sign up for those alerts, and and always, you can't fill out the disclosure, but you can certainly make sure that your seller is aware of the importance of it in filling it out, and actually knows what they're reading and understands what they're reading, and is forthright in what they're providing. So that's
Yeah.
always important. It's just, like I said, it's a starting point in the transaction for the buyer. So it's an important document. We all know that.
Yeah, and we also all need to be on the lookout for that new form that
Right.
you mentioned.
Yeah, we should have a new form. Yeah, on the floodplain construction. Like I said, it's just more of a disclosure. It's similar to a seller disclosure in the sense that it's just a starting point. It's just alerting the buyer to these issues, and if the buyer wants to get more information, then now they can go get it. But now you're just making them aware of it.
Okay. And you said that form should be available this month?
I hope so.
I hope so.
Yeah.
Do you know the name of it offhand?
Yes, it most likely will be, because we have a draft, notice of regulations for construction or remodel in a floodplain.
Okay. And I'm sure we will alert our members
Yeah.
when that's available.
Yeah.
Well, perfect. Thank you again.
Yeah.
All right. So that was it for this Member Focus Monday. We'll be back next Monday at 9 a.m. With Kat Robinson. She's the chair of our YPN group, so she's going to be filling us in on all things YPN. We'll see you then. Have a great week. Bye-bye.